Welcome to Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our website is libertylawtalk.org, where you can subscribe, comment, find other episodes and links relevant to today's conversation. Our email address is mail@libertylawtalk.org. We'd love to hear from you. Today we are discussing with Paul Horwitz his new book, First Amendment Institutions. Professor Horowitz is the Gordon Rosen Professor at the School of Law at the University of Alabama. Paul, great to have you.
Well, thank you so much for having me. Really appreciate it.
So I wanted to open up your book and really get into your main argument. But before I do that, preceding your argument about First Amendment law and how it should open up to institutions and really value them as being constitutive elements of free speech in America, that it's actually through these organizations that we come to, learn, grow, shape, we're educated, and we participate in a free society through these organizations. Therefore, the law should actually take them into account in a more bottom-up way as opposed to, as you say, an acontextual sense that it currently does. I want to get into the argument at the beginning. What is wrong, in your eyes, with the current state of First Amendment jurisprudence?
I think what I would say, and always with sympathy for the difficult path that the courts have to thread, is that it often seeks simplicity at the expense of reflectiveness or responsiveness to phenomena, institutions, aspects of the way we engage in speech in our society that are important. It seeks simplicity in the sense that it wants to come up with doctrines that are universally applicable, doctrines that can be easily applied regardless of who is in front of the judge or the court. And that's understandable, and there are a lot of rule of law values tied up in that, and I'm not attacking it, but I'm suggesting that it does present a tension because inevitably courts are trying to respond to a real-world set of recurring circumstances in which speech takes place, and institutions, especially particular institutions, are relevant to that. And to the extent that the courts want to act as if that's irrelevant or beside the point or unnecessary to their inquiry, they can sometimes end up under recognizing those institutions, under protecting those institutions, and so that's really my concern.
So I was thinking, if you would discuss, I think, some cases that kind of exemplify your concern. You mentioned a few in the beginning. So if we think about the broad contours of First Amendment law, content-based restrictions have to meet strict scrutiny. So largely, when there is a regulation of speech, it's content-neutral regulations, time, place, and manner, primarily concerned with two entities: the state and the private person, the individual speaking, trying to protect the individual. But as you say, largely what we're doing is trying to inhibit the state regulating the individual's speech. But you say this introduces all sorts of flexibility needs, or where the court has to actually stretch in a lot of different cases. One was the Arkansas, which I thought was it's interesting. The Arkansas Public Television station, PBS affiliate, I assume, was going to have a candidates debate, reasonable exclusion of marginal candidates, so you don't have 20 people on the stage, and the court kind of understood that, but yet didn't really have the doctrines to reach that conclusion, as you were arguing.
Right. I think you could call it a vocabulary problem or a resource problem, a problem of lacking the right tools for the right job. So now we probably will discuss later on the kind of complicated question of state actors, but let me kind of start with the assumption that in their day-to-day lives, and I think this was the assumption that came through in the facts, the Arkansas public broadcasters who were making these decisions weren't sitting around thinking of themselves as state actors, government employees, and so on. That may matter for all kinds of legal reasons, but that wasn't how they saw or fulfilled their job. They saw themselves as journalists. They made journalistic decisions, and the court ultimately wanted to respect that, acknowledge that that made a difference, and that this was a reasonable choice that they made to exclude a marginal candidate. Not the only choice, but a reasonable choice. But that kind of deference for what, through standard legal doctrine, might be described as a content or speaker or viewpoint specific decision made by a government employee, that normally doesn't get that kind of discretion or deference. And so the court has to, on the one hand, use the doctrine it has available to it, and on the other, acknowledge the kind of real-world facts involved, and so it ends up potentially either hurting the doctrine or drawing what seem like ad hoc exceptions, when if you were explaining this to a friend, you would have a much easier time describing it and coming to a sound result. Now, I think they came to a sound result, but that's the kind of issue. Do we have the legal tools to recognize what's in front of us sometimes?
So I want to get into really the argument of your book.
Mm-hmm.
So I want to read this passage from page 3,
Yes.
and then just get your comment. You say, a central argument of this book focuses on a feature shared by much important First Amendment speech. It is institutional. Institutions form a central part of the infrastructure of public discourse, or what Jack Balkin has called the infrastructure of free expression. They are places in which some of the most vital First Amendment activities occur. In Richard Garnett's words, they are, quote, the scaffolding around which civil society is constructed, in which personal freedoms are exercised, in which loyalties are formed and transformed, and in which individuals flourish, end quote. The object of this book is to help us see these institutions for what they are, understand how they function, and how they help form the infrastructure of public discourse, and ask how the law of the First Amendment ought to respond to them.
Right. Happy to react to that. So the idea, I think, is if you were to picture or map out or schematize what I call public discourse is, what roughly public speech on a variety of matters is, it wouldn't all be transmitted through kind of an equal set of equally spaced individual dots. It wouldn't look like some random atomistic transformation of information through individuals. A lot of the discussion, a lot of the activity, and that includes obviously kind of identity forming and social activity, as well as straight communicative activity, is funneled through particular repeat players. And I emphasize that not because they are monolithic institutions or because it matters that they're interest groups or something like that. I mean, as people, as citizens, as individuals, we want to interact with and do interact with particular repeat players. The information we get comes from them. The activities we engage in go through them, and so on. So the map wouldn't just have the state on one side and a variety of individual speakers on the other side. There would be a third prominent element, which would be those institutions that form a part of that landscape, that form a part of the as I say, the infrastructure of public discourse. And the question is, both on a ground level, can we see that? Can we recognize it and think about its importance? Can we think about what those institutions do, how they regulate themselves quite apart from the state, and whether that's important, what role it should play? And second, on a doctrinal level, is there anything courts could do more of to acknowledge that?
Now, you argue at several points, you're not arguing for the replacement of current First Amendment law and kind of the monolithic top-down approach you describe that it takes in its central concerns But you're offering a supplement, you say, and this supplement would be responsive to institutional context of speech. And so you've got two principles. One, so that responsiveness to context, and then that the law would be bottom up. So I guess I wanted to ask you, what are the institutions that you have in mind that would be, I guess, privileged under your conception of free speech doctrine, and how would the law work in that bottom up capacity?
Sure, and so let me, if I may, address kind of a number of those
Sure.
points. That's right. So first of all, I'm not disdaining individual speech, nor am I dismissing the reasons that courts try to come up with, as I call it, acontextual or context-neutral rules to approach the law. Generality is important. Predictability is important. Equality in terms of, or neutrality towards speakers is important because you want judges to be restrained and have workable tools. Again, the question is, are those tools completely workable, and do we need more tools in the toolkit? And second, I want to maybe worry about, although I think it's a worry that I try to express in the book, about thinking of these as privileged institutions because I don't think of them as kind of aristocratic estates or anything. I think of them rather as common features, common parts of the map. Most of the time when we say, for instance, that government can engage in speech and that government speech doctrine is going to look different than other areas of First Amendment doctrine, we don't think of it so much as a privilege as we do just a structural feature, and so I guess I'd view that in the same way.
Okay.
In terms of identifying the institutions, the ones I talk about the most in the book are, unsurprisingly, the ones that are most well established, and in particular that have been a part of the evolution of civil society along with the state for a long time, and indeed before the modern democratic state. And they're things like universities, the press, religious institutions, somewhat more broadly private associations, especially expressive associations, broadly viewed, libraries, so centers for public discourse, places where public discourse is formed or disseminated or collected, archived, and so on. And then I talk a little bit about institutions that might be on the margins, might be emerging institutions. I've been a blogger for almost a decade now, and I've argued elsewhere and a little bit in this book that rather than view blogs as the press as such, we might view them as a kind of an emerging institution that over time is developing and arguing about its own norms and best practices. Now, how this works, I think, is on two levels. One is identification, is knowing that, all right, this involves the kind of institution that we typically recognize as a kind of a fundamental locus of First Amendment activity, as an infrastructural part of public discourse, engaging in something like that activity. So, the New York Times publishes a story or does a reporting or a variety of things that easily, intuitively fall within the kind of activity that we recognize it as an institution for. Might do other things, stock swap or something of the sort that really aren't central to its institutional role, that don't distinguish it in that capacity. And to the extent that we kind of identify it, we say, all right, well, when we're approaching questions involving its activities, we want to give it a broad berth. We want to defer to it in the same way that courts often defer to administrative agencies, both because of legitimacy reasons and because of expertise reasons. And to the extent that that conclusion depends on the idea that, well, these institutions actually engage in a good deal of self-regulation and ought to have discretion to operate within that framework, then there are going to be limits. There are always limits, but we try to let those limits emerge from the best practices of those institutions rather than courts trying to come up with a rule and then apply it.
Let me, I just want to go through on page 10. You have a nice list of how your argument might alter or change a First Amendment doctrine, and I'll just read a few.
Sure.
I mean, they're all quite interesting, but the ones I'll share. So you say, granting the press new constitutional privileges to conceal sources and to engage in news-gathering practices without legal interference, expanding universities' rights of academic freedom, including the right to engage in behavior such as enforcing speech codes and excluding student groups that they believe improperly restrict membership. Treating religious entities as largely sovereign institutions, immunizing them from civil rights laws and other statutes, strengthening voluntary associations to operate without legal interference, and this, I think, is crucial in the way people will react to your book, breaking down the legal divide between public and private entities and allowing some state institutions, I guess that would go back to universities would be one, to operate at or removed from state control, and then rethinking some of our most sacred rulings in the area of race and civil rights that may allow institutions to openly discriminate on that basis. So this is all kind of some would say radical, and I was thinking about your argument that you're merely supplementing, and I kind of thought, but also I thought the list was interesting and thinking through the implications of your arguments, because someone could say, well, this is just about really not just limiting government, but making government small and really having a robust, thick, soupy civil society, which is certainly fine by me. I know others might react to it, and yet. That's not necessarily the case, right? I mean, as we've just been discussing, both with, say, PBS, that case, or with universities. So I take it, just from that list, FIRE would not necessarily have the same umph to it. The Foundation for Individual Rights and Education and their efforts with speech codes, maybe, because we would we would want universities to participate in that public discourse the way they saw fit.
I think that's right. Again, your listenership, which may be diverse in its views, but I could imagine some people having problems with some of the items on this list and others having problems with others. This is really an opening. The book is really an opening to a conversation, and I'm still thinking through some of these issues, so I want to put it in the right framework. I think, indeed, we can, and I'm sure we'll talk about some of the specific issues. I think I want to emphasize that I am thinking about, I think, a thick civil society, and I am saying something, therefore, about the limits of the state. Now, for me, philosophically, it's not so much kind of that I'm seeking a smaller state as such, as that I'm suggesting that there are other institutions that fulfill some of these roles quite importantly and in a quite established manner, and that it may be better in many respects to think of them forming these rules and traditions and practices than to think of the state imposing it. There are some areas where I'd probably make an even more emphatic statement. Religious associations is one. And I'd also say that, well, two things. I'd say, first of all, that this freedom, so to speak, really legal autonomy to make decisions, is not therefore an endorsement of all the decisions that those institutions would make. I don't want to be at a university that has a speech code. As an academic who is a member of such an who is a member of an academic institution, I would resist that. I would speak against it, and as a citizen, I would feel entitled to speak against it, indeed obliged to speak against it. And one kind of undercurrent of this book that also appears elsewhere in my writing is to think about the obligation of citizens and institutions, to the extent that they are granted autonomy, to take full responsibility for engaging with those institutions, engaging in self-reflection and debate if you're a member of a particular institution, or as a citizen engaging with these institutions. So I believe strongly in religious autonomy and the autonomy of religious groups, but I think that places a heavy moral and civic obligation on those groups to consider their actions and to ensure that they self-regulate. And I think that it means they're not immune from public criticism, that it's okay to say to a religious organization, you ought to have the autonomy to make a decision on a particular policy, but that's the wrong policy, and to engage them in a kind of forward fashion. So it's not always about making the right or wrong decision. It's about making an institutional decision as an institution according to its proper traditions, and about arguing that might be better than top-down state regulation. And second, an important theme of the book certainly is institutional pluralism and institutional diversity. So where I think, and I don't want to overstate this. I mean, I certainly think FIRE, for instance, has taken a different approach to some universities because they're religiously affiliated or operate according to other norms. Its most stringent criticism is seems to me devoted to those institutions that purport to value a particular brand of academic freedom and then don't, and that's fair game. But my view is that there is room within institutions for a variety of approaches, and so what I worry about to some extent is courts applying a single vision of what an institution is across the board rather than allowing for diversification. And I think finally, one of the ways that we deal with that question of institutional pluralism is to draw a line between public and private, so that we say, all right, private universities, for instance, can do X, but all public universities have to do Y. And that's, I think, what we try to do in part with the public-private distinction. It's valid. I don't think, though, that it is always sufficiently, targeted or responsive to certain kinds of public institutions. I mean, the real argument is not so much that I don't care about the public-private divide as that it's not the only available description and not always the best description.
I take it, reading your book, I think an overall holistic read is what you're aiming at is something like a lot of micro deliberative democracies where people actually, through kind of a robust association, realize themselves within a free society apart from a lot of state interference. That this is actually a good in and of itself.
I think that's fair. Maybe my only hesitation would be thinking of all of them as deliberative democracies. One of the kind of bigger arguments or questions in thinking about liberalism and freedom of association, and it really very much comes up these days in actual cases involving religion in particular, is the extent to which private associations have to model the rules of liberal discourse in the public sphere. Yeah. And my view, and it's certainly shared by some both kind of classical liberals and non-classical liberals, is no, they shouldn't have to. They shouldn't have to model or adopt liberalism all the way down, and the state shouldn't impose those kinds of rules of discourse on every association. So I assume, for instance, that a hierarchical church doesn't have to be a deliberative democracy.
Okay. Yeah, I think I think that's right. I guess I didn't mean democracy in the sense of their norms and their principles are always up to change, but that people are actually participating in them in some capacity.
That's right.
Yeah, it is interesting too. Just going back to your discussion about private associations, and just thinking of, this doesn't end necessarily the conversation with a public university with the speech code, but actually compels people to step forward and criticize. And I was thinking of just, this is a private university, but Vanderbilt University, which received a lot of press, and it's hard to argue, I think, that Vanderbilt's come out ahead particularly within the state that it operates, to the extent it cares, of enforcing a non-discrimination clause that has effectively removed a lot of religious student groups. And of course, there was a really robust discussion on campus about that. And I suppose that would be kind of a model that would develop, at least on state universities, perhaps, if the change you're talking about occurred. I wanted to say I kind of approached your book as well through Robert Nisbet's book, The Quest for Community, and I think in this sense, which Nisbet argued that the context for freedom, or even the context for individualism, had largely broken down in the 20th century under the wave of kind of the ever-growing democratic state, and so you really had two densities. You had man and the state. And I was thinking in the context of the United States with free speech law, and why I think your book is so interesting. You've got these two densities, but both are growing and have incredible power for different reasons. The state, I think, largely we see a progressive state in pursuit of kind of a egalitarian understanding of its purposes. We also have man. It's the way we understand. I think the person now is largely autonomistic. And happiness kind of comes from the self-sovereign principle, and so but these things are kind of butting into one another. They're both aggressive and expansionary, and yet you've got the third density, which I think is a different way of thinking about life in a democracy, in the sense of it's not just a spontaneous thing, but actually institutions matter. If I value my own freedom, I need to actually support them as a separate legal category with standing.
I think that's right, and let me talk about that and maybe come back to Vanderbilt, because it's just an interesting issue. I think that's an absolutely fair description, and certainly it's an idea that has been part of public discussion in this area for a long time, and I'm influenced, I think, both by Berger and Newhouse on mediating institutions, and by some of the older tradition of British pluralist writers around the turn of the century. So I would say that's absolutely right, and I think in thinking about the evolution of the state and of modern liberal democratic societies, it's vital to remember that it did not evolve alone. It was not the only institution there. That fundamental part of that broader infrastructure that included the state was always these other institutions. They always served a vital purpose of both counterpoise to the state and as a place in which people found shelter and found identity and found richness in life, as opposed to being a bunch of billiards crashing around on a table. So I do think that depiction of three densities is a great way to put it. The Vanderbilt case is interesting. My view is that it was wrong. I mean, that's kind of my vision of a university, and I think it's Vanderbilt's own vision, or at least that's the traditional vision that Vanderbilt comes from. So I'm troubled by the exclusion of student groups, as I would be by speech codes. I can imagine, though, some room for a university to adopt a different approach. A religiously affiliated university is an obvious example, but within the sphere of what we consider liberal universities, I could imagine that one university focuses on a kind of free-for-all, and another focuses on a very particular model of civility in the academic community, or equality, or liberty, or something else. And I think there's room for that. And then, yes, room for the members of that community to engage it, to criticize it, to be obliged to think about it instead of kind of sliding into it, which is, I think, what often as a practical matter happens, and for it to, so to speak, own up to making a decision about its academic mission, declaring it, and then living by it, or being criticized for it. And so I think, in a sense, that's the way we need to talk about these things. And there are times when we put these things so quickly into legal terms
Yeah.
rather than institutional terms, that we lose some of the thickness of the discussion.
Yeah, no, I agree with you. So I'm thinking now of, I was thinking of hypotheticals, and what kind of led me to that is thinking about the self-regulating practices.
Hmm.
And what you have used the term bounded autonomy to refer to institutions and their relationship to the government under this doctrine. I'm thinking largely if the court is going to determine if you followed self-regulating practices in order to give you deference under First Amendment law, if I'm stating that correctly,
Yep.
please correct me. If they do, are we not inviting in potentially government in a paradoxical way, looking even deeper into institutions and evaluating it? Because I was kind of thinking along the lines of, so courts never get into actual church law. Because they don't want to make a theological judgment ultimately, and property disputes or things like that. So I'm thinking, but it's the question of universities, of courts actually getting involved, or the press, and looking to see. So, and then I was thinking it requires a lot of factual knowledge as well. I would think. To make those decisions potentially would require a highly specialized understanding. But thinking of like tenure review case or these student associations, and the courts looking in. Did you apply the clause unevenly? How do other universities apply it? How would we make a judgment as to what uneven is? All sorts of things. So I guess I just wanted to put that to you.
Sure, and let me say candidly up front that I think there are dangers. And one thing I try to do in the book, especially at the end of the book, is to try to think through the objections and raise some of the things that we should be worried about under such an approach. And so I emphatically don't want to kind of provide a utopian promise here. Rather, the question are those dangers any worse, all things considered, than the frailties of the current approach, or what we actually do under the current approach, where we sometimes do defer to these institutions, but as I said, lack the language with which to do so. So I think my answer is yes, it is a concern. Now, what I say in the book is, first of all, that I think that we should be deferential about the scope of deference. That is to say, so clearly there are, if we're trying to protect institutions, particular speech institutions as institutions, then we got to identify them as such, and agree that they're acting within their function, broadly speaking. But it should be broadly speaking. It shouldn't be a narrow description where you say, well, you're a university. All universities must behave in the following fashion, and you're not. Therefore, you're outside of the scope of deference. That I worry about. Rather, I would say, you're a university. There's a fairly broad range of practices or norms that might fall within that scope, and so we're going to defer on the scope of deference. I assume that there are still ultimately limits, but I would be deferential even in the approach. And the second thing I would say is, to some degree, without wanting to state it too definitively, there's a degree to which what you could look for is a kind of a due process, at least in the common run of cases. So imagine a university tenure decision, or any number of decisions by a university or a church. Well, actually, with churches, I think probably you're going to be even more deferential. But what you would say, at least to a university, is, well, you're asserting that you acted as a university in making an academic decision. There's no evidence at all that you acted, that there was any academic deliberation. Go back, deliberate, and if you do so, even if you reach a decision that we would disagree with, then we'll accept that. And there's, I think, an example in the book of a case involving Boston University where a decision, a policy it took, was challenged. The court said it's not clear that the university actually considered the issues in the way it's saying or according to its own norms, remanded. Then the university said, well, we've done that, and we've reached the same decision, and the court said, fine.
And the court said fine.
Mm-hmm.
That's interesting. I was thinking in terms of an institution belonging as well
Mm-hmm.
in the scope of your book. So you've got universities and schools, press, churches, libraries. I was going to ask you libraries. That kind of caught me off guard. I don't really think of them as having much of a role anymore.
I think that's a fair point. I'm not. Actually, I'm kind of happy to reflect on that. I don't think that they are as central, certainly not in the imagination, the public imagination, as they once were. It is, I think, probably two or three reasons I ended up focusing on them. I think they do have an important structural role, historically speaking.
Yeah.
And with each of these institutions, to some degree, I tried to use the individual chapters discussing them, both to talk about the institution and then to use that to illuminate new issues. So, for instance, with the press, I talk about the press, but I also talk about new media, emerging institutions, and use that as a way to talk about what we do with emerging or borderline institutions. And with libraries, I think the kind of interesting issue is that however private libraries might once have been, now we kind of think of most of the typical archetypal important libraries. They're public libraries, and we think of them as operating as libraries according to the history and tradition of libraries, and yet they're public institutions. So it provides a good avenue to think about what it means to be both an institution, a speech institution, and also a publicly funded body.
I was thinking as well with regards to, then you list voluntary associations. That's another group. So I think there's a couple of questions. And I was going to ask you one, business startups, and just thinking of entrepreneurs actually really seeing themselves. I mean, their understanding of who they are and how they engage a free society coming through the businesses they create. And then largely, if you think about the employees, I mean, that seems to kind of follow. Is there any sense in which that would be or could be part of your list, or is it, as you also talk about with regard to associations and separating them out, business, the market, and the state are so closely intertwined with one another that you want to find a definitive principle where the association occupies another space in order to give it that protection. So,
I guess I'd say this, that what I'm talking about in the book is institutions that I think play a central and recurring role in public discourse.
Oh, okay.
Yeah, so no question that businesses, entrepreneurs form a central part of society. Not as clear to me, at least, that they form a central and again recurring infrastructural part of public discourse.
That's a good distinction. Although it is interesting how much more political these groups are becoming. It seems, just in terms of the things they'll support or give voice to, or what they'll choose to donate to, et cetera.
I think that's fair. I talk a little bit about commercial speech in the book, and I certainly take the view that, for instance, to take the not so old, but the Nike versus Kasky case, that's political speech and should be viewed as such. I think that there are interesting questions or cases kind of in between, but often enough businesses operate for and according to the logic of the market, or maybe the regulated market, but aren't about public discourse as such. Not that they shouldn't be respected, or that we shouldn't, in general, try to have a institutionally appreciative cast of mind, but this is not totally a one-size-fits-all tool.
No, yeah, and I think going back just to your self-regulating principle and functional evaluation, and even this idea of social philanthropy that they're engaging in, philanthropic works, is also largely, we can be cynical about it and see it's tied to the business model as well. I think for most of them, that is true. I was going to ask you about just the institutional forms of developing, because if we've got these 5 categories and then some subcategories and then a few of them, everybody, it seems to me, rushes to get in there to have that freedom. But I just thought, is that actually going to be good for those organizations? I mean, how might they be inhibited in that regard because of the distinctions that you made? I mean, so could we actually, an unintended consequence maybe, that we have civil society stasis as well? And then maybe we can end just thinking about, so going back to kind of what I think is a really radical part of your argument, and that is the challenge to individualism and how we view free speech, and also equality. The equality of viewpoints is not maintained.
So I think I would say, and maybe to some degree, this kind of answers both questions. Again, clearly, I have great respect for individual speech. Still think of many of the rules of First Amendment doctrine as valuable and important, and also, if not completely stable, then having some degree of stability that's important. I think it is true that I present a challenge to a description which the law sometimes seems to represent, of there being nothing between the state and the individual, and of free speech doctrine being formed around a vision that kind of any random speaker comes up, and a single monolithic state comes up on the other side, and that's the picture that we paint. And I say, that's not quite right. Individuals are social creatures, and they don't kind of randomly socialize, but there are particular institutions that have played an infrastructural role in the way we talk to each other, share, debate, and so on, and that's important. There has been, certainly, and I should say I've been, inspired by the work of Professor Fred Schauer on some of these issues, and one of the early responses to one of the early pieces he did on institutionalism and the First Amendment was along the lines you're talking about, social stasis. Put a little differently, it was basically, if we let judges define these institutions, then they'll favor their friends, favor established institutions. I think that's a fair concern, and I talk about it toward the end of the book. I think it is a potentially overstated concern, in part because I'm trying to also emphasize, again, a fairly deferential understanding of what an institution is, and an idea that within that broad institutional definition there will be pluralism, ought to be pluralism and development and evolution, and I think that's important. And I would say finally that I think to some degree, what you describe is actually a standard part of the process for any emerging institution. I mean, blogs being an example.
Yeah.
They kind of started latching on to a press model, moved away from that model, both in terms of their own norms and maybe in terms of the metaphors they would apply. So I think that's organically going to happen. It's not just a legal artifact. And that's one reason that I see this as a supplement rather than a replacement for all of First Amendment law, because I think in that space when institutions are emerging, it's important that they have protection, even if we don't think that their habits and function and role and importance is so routinized and clear that we want to give them some kind of categorical treatment.
So I lied. I want to ask you 2 more questions, and I'm just thinking this is really interesting to me. So let me just ask you. So thinking about that due process that you were describing, so the institution wants to change. I mean, do we have a process where they kind of tip their hat to the court? Should these institutions, is there some sort of way they get together and kind of communicate that, well, so we are going to change how we evaluate the tenure review process, or we are going to change our regulating norms with regard to student groups? Just think about those 2 examples. Or, how the press is going to change how it evaluates, I don't know who it's going to feature on its op-ed page, or I don't know, trying to think through all the different ways that evolution could happen. Within associational life as well. I mean, you could see a number of ways that these volunteer associations might do things that run up against the cultural zeitgeist, haven't been a part of their practice, but they think need to be. And so I put that to you. I just kind of thinking, how is that sort of listening, reflective process going to happen?
Well, I think part of the answer is that apart from the law, and whether or not the law existed, that would happen and does happen anyways, and would happen kind of organically, incrementally, and ultimately would happen at the both at the level of an individual institution and at a macro level. So I think one point I'm making is that those developments generally take place in a meaningful fashion. I won't call it responsible or irresponsible, but they take place in a kind of a thoughtful evolutionary process of self-examination with missteps along the way, but I think they do happen. And so I think it's important to see that whether or not we talk about it in a legal framework. And in that sense, and it can go in of course, any direction. Doesn't have to track a kind of conventional liberal conservative line. And in that sense, I think the courts should take a broad sense of the limits here, of the institutional limits here, and allow some of that evolution to occur without early intervention. An example, I suppose, would be the JC's case, the famous freedom of association case, in which, as it turns out, and it's talked about in the appeals court decision, the question whether women should and could be full members was being actively debated in the group.
Yeah, that was interesting.
Yeah, and I think we're seeing the same thing with the Boy Scouts debate right now, and one can argue that the Boy Scouts ought to do one thing or the other, but it's inevitable that there's going to be a relationship between what goes on in the group and what goes on in society. And so the question is, do we think of these groups as only changing in response to state law, state imposition of non-discrimination law, for instance, or do we think of them as having a kind of meaningful discussions in response to changes in view and changes in circumstance, and sometimes deciding, for instance, that they are going to take a different position, sometimes deciding that they're going to be a genuine bulwark against social changes.
Yeah.
And I think there's room for both.
No, and it's interesting to reflect. I mean, in thinking of this sort of let's say overall society operating by these principles. I mean, actually, we have a lot more to be political about. I would think, and as this process would develop, as actually you could see much stronger modes of political process or political participation occurring as people have these more stronger identities that are formed in these organizations, which would seem, if a principle is laid down that they should be largely autonomous and free of the state, that signals, I think, their importance. People take them more seriously, I think, form more robust identities, different identities, and actually that becomes what they're political about. So it's actually kind of interesting. It could be, a lot of new emergent ideas out there.
I think that's right. I hope that's right. I've written a lot about law and religion, and I've been, fairly big champion of the autonomy of religious institutions, and my view, my argument has been the court decision that it has autonomy, doesn't have autonomy is just the beginning of the conversation, and that in a sense, autonomy is described as freedom to be left alone by the state, and that is true. But that is like
it's a freedom.
That's like telling your parents, "I'm an adult and I want to make my own decisions," and they say fine, and then suddenly you're faced with the burden of making those decisions. And that's really what adulthood is about, and I'm saying that kind of civic adulthood is about having those conversations.
Yeah. Great. The book is First Amendment Institutions. We've been talking with the author, Paul Horwitz. Thank you so much.
Thank you very much for having me.
This is your host, Richard Reinsch, and you have been listening to a podcast that can be found at libertylawtalk.org, where you can subscribe, comment, find other episodes, and links relevant to today's conversation. Our email address is mail@libertylawtalk.org.